The other two elements of criminal law are uniformity and penal sanctions. Uniformity. It is indeed in the definition of criminal law that law attempts to provide even-handed justice without respect to persons. This means that no exceptions are made in criminal liability because of a personal social status. An act described as a crime is a crime regardless of who perpetrates it. Uniformity also means that the law enforcement process shall be administered without regard for the status of the persons who perpetrate it. Uniformity also means that the law enforcement process shall be administered without regard for the status of the persons who have committed the crime or been accused of committing a crime. However, this idea varies in practice. The question is, are all offenders treated alike? The rigid rule treats all persons in the class to which the law refers exactly alike, while judicial discretion takes cognizance of varying elements and situations of the members of the class, and thus appreciates liability closer to individualization. Thus, the court looks at the circumstances of each case. Article 98, Clause 4 of the Constitution of the Republic of Uganda, 1995, exempts the President from liability. Thus, while holding office, the President shall not be liable to any proceedings in court. Penal sanction. This notion means that violators will be punished or at least threatened with punishment by the state. Note that punishment under the law differs from that imposed by the mob in that it is applied dispassionately by representative of the state in such a manner that it may win the approval of the court under the judgment of impartial objectives. Law that does not provide a penalty that will cause suffering is regarded as quite ineffective, and in fact, no criminal law at all. The punishment for a crime may be very slight. However, in the courts of law, the verdict was reached, a party declared guilty, and the disgrace of the declaration of guilty was the punishment, e.g., in a case where an accused person is questioned by court. The Constitution of Uganda also provides that the punishment of an offender must be specific. Article 28, Clause 12 of the Constitution of the Republic of Uganda, 1995, provides that, except for contempt of court, no person shall be convicted of an offense unless the offense is defined and the penalty for it prescribed by law. Thank you for watching. Subscribe to the channel and hit the notification bell to receive notifications whenever such content is uploaded.